Welcome back to the HALO webinar series. I'm Hannah Fisher and I'm the president of Hoosier Animal Law Officers. Last month, we discussed common Indiana animal-related laws that are used for investigations and enforcement actions. If you haven't watched that one yet, I encourage you to do so. It explains in depth the laws that are relevant to the topic we will discuss today. Today we will discuss what is referred to as the bond statute. This statute, IC 354636, explains what happens after an animal is impounded for a violation of the laws we discussed last month. As a disclaimer, this webinar and its videos, pictures, and other associated content has been compiled by HALO Incorporated. The information in this webinar is for educational purposes only, and it is not intended to provide a substitute for consulting with legal professionals. The formal name of the statute is Impoundment of Animals, Probable Cause Hearing, Penalties, Custody, and Bond. You will commonly hear it referred to as just the bond statute or the pre-conviction forfeiture statute. The ultimate goal of an animal cruelty investigation, if it reaches the point of criminal violation, is to remove the animal or animals from the conditions or environment in which they were found. So if you or the law enforcement agency you work with determine that a violation has occurred, you need to know how to proceed once the animal has been impounded. It should be noted that there is some discrepancy across the state on how this statute is used. First, some jurisdictions don't use it, which I've never understood. Not only does it create a huge burden on the impounding agency, but it is also written into state code, so I don't understand how they aren't using it. There's also some disagreement on how it should be interpreted. We are going to work through the most commonly used interpretation of this statute. Please note that this presentation has previously been presented to state prosecutors at the Indiana Prosecuting Attorneys Council's conference, so we are confident in our interpretation and application of it. Further, the statute is somewhat confusing until you read through it and use it a few times, so I encourage you to watch this webinar start to finish and then again start to finish. In all honesty, some of the individual parts will seem unclear until you learn the other parts, so if you watch it more than once, it should put it together for you. To start this off, who can impound an animal? As explained in the statute, any law enforcement officer or any other person having authority to impound animals may do so if they have probable cause to believe there has been a violation of IC 3546.3 or IC 1521.4. The persons covered by any other person who has authority would stem from local ordinances and policies. There are two good examples of the application of this statute that appear in Indiana case law. Both Baxter v. State and Trimble v. State discuss the warrantless exception for removing animals. But further, in Baxter v. State, the defendant argued that the state erred in not allowing him to sell horses that had been seized from him for violations of Chapter 3. The state relied heavily on the statute's requirement for an owner to post bond to prevent disposition of the animals. Since Baxter never posted bond as required, nor did he request a probable cause hearing, the court held that he had no right to sell the animals. I encourage you to read both of these case laws to learn even more. They are relatively short reads and are good information to know. Once it has been determined that an animal is being removed from the property, the bond statute is initiated. There is no formal court order that has to be issued. Impound day is day 1. It's as simple as that. In the statute, there is no requirement to notify the owner that they are required to post bond, meaning you could impound an animal and the animal's owner is just expected to know the requirements of the statute. However, most jurisdictions and agencies do provide some sort of notice that says, in a slightly more articulate way of course, hey, I took your animal, you have 10 days to pay X amount of money or we get ownership rights. These notices can be in a variety of forms. Across the state, we see in-person explanations, door hangers, notices, and certified letters. Since there is no statutory requirement, the biggest thing here is to be consistent. If you're going to not notify, don't notify any of the owners. If you are going to notify an owner, make sure you notify every owner every time in the same manner each time. Here, in a nutshell, is why this statute exists. When an animal is seized, it is more or less evidence. However, think of this profound difference explained in the article, Time to Feed the Evidence. Animals are legally classified as property in the U.S. However, they do not behave like other property. Most evidence is inanimate, so its condition does not change over time unless someone permits it to, degrades, or tampers with it. The same is not true of animals. In fact, the very reason for seizing neglected or abused animals is to change a condition by altering their environment. Therefore, although the animal is initially the evidence, they do not remain the evidence in a way. The pictures, videos, vet records, reports, lab results, etc. become the evidence because the animal will and should change condition. Animals, because they are living beings, cannot be put in an evidence locker and forgotten about. They require care daily and are expected to change conditions. This statute helps expedite getting them, quote-unquote, unstuck from the system, so they are not sitting in a shelter facility for the months and months that the court case may take. As mentioned, upon first being impounded, the animal's condition was the evidence. However, if you don't go to court until 6 months from the date of impound, the animal will not be in the same condition. In fact, it'll probably look like a completely different animal. It should be an appropriate weight, be healthier, be acting appropriately, and not ever look like it was even neglected. So if you bring that evidence into the courtroom, you are going to get very confused looks. That is why the documentation of the animal's condition upon impound is so crucial. Your pictures and videos and vet records become the evidence that you will later produce to the courts. An animal, unlike a seized knife or bloody shirt or shell casing, isn't going to look at all like it did when you put it in a bag and into the evidence locker. That said, since the animal itself doesn't remain the evidence per se, it needs to be treated differently. Animal care depletes resources of the providing shelter and costs the agency money. The bond requirement makes the owner pay for the care, or it allows the impounding agency to move the animal along in a manner deemed most appropriate, typically being adoption. In addition to the fiscal drain on an impounding agency, an extended shelter stay for a shelter animal can cause undue stress and behavioral problems. So what will happen to an already sick and distressed animal that you put in that situation? This statute, again, helps expedite getting them into a new long-term arrangement. As discussed, the ultimate goal for utilizing this statute is to get the animal out of the impounding facility as quickly as possible. However, there are two ultimate outcomes. First, the owner could fail to post or renew bond, allowing the agency to take ownership of the animal. This is ideal. But an owner could pay the bond, which would keep the animal in the facility, but it would at least offset the payments of the care of the animal. This is not ideal for the animal, but it does at minimum help cover the burden of the agency. Now that we have mentioned posting bond several times, what exactly does that mean? In the statute, the wording reads as such. The owner of an animal that has been impounded under this section may prevent disposition of an animal by an animal shelter that is caring for the animal by posting, not later than 10 days after the animal has been impounded, a bond with the court in an amount sufficient to provide for the animal's care and keeping for at least 30 days, beginning from the date the animal was impounded. So let's work through this. First, what disposition is posting bond going to prevent? The disposition of an animal is basically any drastic change to it or transfer of ownership. Within those first 10 days after impounding, and during the time in which a bond has been placed, an impounding agency cannot do anything that is not medically necessary to the animal, meaning the animal can't be sterilized, microchipped, ear-tipped, tail-docked, declawed, etc. Now, a lot of those procedures are not common practice anyway, but I'm just giving examples of things that you really legally cannot do while the animal is not yours. Any physical alteration that is not medically necessary could be deemed a violation of a person's Fourth Amendment rights because it is still their property. Now, things you can do include medically necessary procedures. Obviously, if you have an animal with a prolapsed anus, a fractured bone, a maggot-infested wound, etc., you can address those. The key is document everything with pictures, vet records, and reports. The other big no-no during the 10-day period or the time in which a bond has been paid is adoption. That animal still belongs to the owner. You cannot transfer ownership, period, end of story. So what is the 10-day period? It is 10 actual days, not weekends, not holidays, not business days, 10 actual days. For example, if you respond to an animal and impound it on a Friday before Memorial Day Monday, day 1 is Friday, day 2 is Saturday, day 3 is Sunday, day 4 is Monday, etc. 10 actual days. Now, in terms of the bond amount, that's specific to each jurisdiction and agency. We'll get into that more later. Another caveat of this section includes the opportunity for an owner to request a probable cause hearing. If the owner wishes, they may file this request with the court having jurisdiction of criminal charges under this chapter. If you have an owner inquire with you about this, you should refer them to the court in which charges are filed for animal-related offenses. Or, if you don't know which court it is, refer them to the prosecutor's office. But then, for your own knowledge, you should probably figure out which court your county typically uses for animal-related offenses. If the owner happens to post the initial bond in the 10-day period from time of impound, disposition is prevented for a 30-day period. However, the owner must then renew the bond every 30 days, again with 10 days, to continue retaining ownership rights. So basically, day 30 becomes day 1 again, and the bond must be renewed by day 40, which is the new day 10. The cycle then continues until no renewal is posted or a court orders otherwise. So, how do you determine how much your bond should be, and where does the money go? First off, you must fully comprehend that the bond is not a fine or a fee. It is the cost of the care for the animal. It is not a punishment, nor is it a consequence per se. It is a payment of necessary food, shelter, and care for the animal. Bond amounts differ across the state and are based on a variety of things: species, medical conditions, shelter used, etc. Some agencies have set amounts per animal. Common ranges seen are $300 to $400 a month. Some agencies set the amount based on the individual animal's condition. These are questions you need to discuss with your staff, prosecutor's office, county and city attorneys, and other officials in your jurisdiction. Now, owners have been known to make the arguments such as, well, I could feed my dog for 50 cents a day on Alpo, but the bond cost covers, in addition to food, overhead costs for the facility, staff wages, vet care, etc. Additionally, appeals have been tried claiming that it is an excessive fine and therefore a violation of a person's Eighth Amendment rights. But again, this is not a fee or a fine. This is the cost of care for the animal. Once you determine what the bond amount is going to be, you must figure out how the money will be processed. Some larger freestanding agencies and shelters process the money in their own budgets and money lines. However, more commonly, you will see a city or county clerk's office process the money and then release it to the shelter or rescue. Again, this is something you need to arrange within your jurisdiction. So if you get to day 11 and no bond has been posted, what happens? In the statute, there is no explicit requirement for a court order to terminate ownership. Simply put, the way the code reads is if day 11 comes and no bond has been posted, ownership rights default to the impounding agency, and they can therefore do as they wish with the animal. Of course, if it's legal and humane. Some jurisdictions will still secure a court order based on failure to post bond, but the majority of the jurisdictions just default ownership on day 11. Now, in terms of failure to renew a bond, a court order is needed to terminate ownership. You should work with your prosecutor's office to be sure they are pushing for ownership termination if the bond is not renewed. This helps the animal even more. In addition to the bonding requirements, Section 6 also articulates the need for BOAH or their designee to be involved. ACOs, for the most part, are not veterinarians and do not have comprehensive training related to animal health, anatomy, and physiology. Now, we do acquire this knowledge throughout our careers, but we do not have DVM after our name to make us the expert in the eyes of the court. Therefore, the law requires the state vet, which in Indiana is the Board of Animal Health, or someone they appoint to serve as the expert. This means that a veterinarian of some capacity will examine and evaluate the animals and the conditions in which they were found. Now, although the statute reads that when charges are filed, the state vet must get involved, we encourage this contact to be made as soon as possible after the animals are impounded. BOAH vets can create reports based off of pictures in your notes, but it is much more profound if they see the animals as close to the date of impound as possible. After all, charges may not be formally filed for a few months, and by then the animal's condition should have changed. We will talk about BOAH and their involvement more in next month's webinar. So what happens if an owner continues to renew bond? Well, they retain ownership rights, but you continue caring for the animal. In case it wasn't already clear, posting bond does not mean the owner gets physical custody of the animal back. The animal remains in your care, they just keep the ownership rights. But if an owner continues to post bond up until the time of court, the judge ultimately makes an order on determining ownership rights. This decision will usually mirror the outcome of the criminal charge findings. If the owner is found not guilty, they will probably get the animal back. If the owner is found guilty, they should not get the animal back, especially since now in Indiana, during the duration of a person's sentence related to an animal offense, they cannot own, harbor, or care for an animal, so that giving them an animal back upon a conviction would actually be against the law. Now, we have talked a lot about an agency's inability to do anything drastic if an owner retains ownership rights. However, obviously, if an animal is in such dire distress that euthanasia is warranted, that is permitted. However, document everything and be sure you are acting in good faith. It is also strongly encouraged to have veterinarian's recommendation, preferably a BOAH vet, to euthanize. That way, when you get to court, you have ample backing as to why you had the animal euthanized. Further, if you have an animal euthanized while in your care as part of a criminal investigation, have a necropsy performed. Lastly, please do not ever bring a live animal into a courtroom. First, animal behavior is unpredictable. We do not want drama in the courtroom. Second, the animal's condition will have changed, and if you bring a seemingly healthy animal into the courtroom, you are going to confuse your jury or your judge. And last, the animal is no longer the evidence. Bring the real evidence, the pictures and documentation from the time of impound. Now that everyone is thoroughly confused, let's do some recaps on this section. First off, animals are not inanimate evidence and should not be treated as such. ACOs and law enforcement officers should be completing thorough documentation of animals' conditions upon impoundment. This becomes your evidence later in court. The act of impounding an animal initiates the 10-day bond period. There are no further requirements or court orders needed. Failure to post bond within 10 days awards ownership rights to the impounding agency by default on day 11. However, failure to renew a bond does require a court order to terminate ownership rights. And lastly, prosecutors should push for no owner, no keeper upon conviction, as is required by law now. Thank you for taking time out of your busy schedules to follow along with this webinar. We hope that this helped shed some light on the bond statute used in Indiana. As always, if you have further questions, don't hesitate to contact us via Facebook or our email addresses, which can be found at HoosierAnimalLawOfficers.org. Stay tuned for next month's webinar when we talk about various resources across the state. Thanks again, and be safe out there.